Hi there, how are you doing? In this class, we're basically going to look at an interesting topic, and that is the topic of res judicata, or also known as claim preclusion. We are going to provide for the law that actually provides for this principle, and then we'll also proceed to define what the principle is about. We'll also look at the doctrine or the maxims on which the doctrine is based. And then, of course, finally, we'll also look at what actually the factors that must be met for someone to actually plead or rely on that principle of res judicata. So, ladies and gentlemen, let's start right away by looking at the position of the law. And I encourage you to look at section 210, subsection 1 of the Magistrate Courts Act, which provides for the principle. And actually that section goes on to state that no court shall try any suit which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties. So basically the law is trying to say that a court is not allowed to go on to hear a matter or determine a matter which was actually initially determined by a court before, and parties were litigating under the same title, meaning these are the same parties, same facts. The law actually prohibits that. Now, the doctrine of res judicata bars a party who brings to court a new case where there has been a final judgment and is no longer subject to appeal. Okay, the legal doctrine stops continued litigation of a case on the same issues between the same parties. Now, what you must note here is that the matter, okay, must have been already the judgment was entered, and the matter is no longer subject to appeal, meaning that the matter has already been concluded. Okay. Now, the matter cannot be raised again, either in the same court or a different court. The court or the defendant will raise the doctrine of res judicata to deny reconsideration of the matter. So this doctrine of res judicata can actually also apply as a defense in situations where you have been sued by a party who had actually sued you previously, and judgment was given, and the case is no longer subject to any further appeal. So you can raise this as a defense. Also important to note is that the doctrine, among others, also prevents the wastage of resources, okay, and also stops continued litigation or endless litigation. It prevents injustice to the parties of a case, supposedly a case that has been finished. It also prevents judgments from contradicting themselves. That is actually why the doctrine of res judicata is actually important. Let's now proceed to look at the two maxims on which this doctrine of res judicata is actually based. So this doctrine basically has two maxims, okay? And these maxims rightly so form the reasons, okay, for the doctrine. The first maxim is actually in Latin, and it states interest republici ut finis litum, which basically means that there be an end to lawsuits. So the reason why res judicata, or also known as claim preclusion, is important, it's based on the notion or the maxim that there must be an end to lawsuits, meaning that parties can never litigate until God comes back. Okay, you can't keep on suing a party and appealing until it cannot end, meaning that litigation has to always come to an end. Okay, then the second maxim is also in Latin, which basically it's abbreviated in Latin to mean nemo debit bis vexari pro ut ist edem cosa, which basically means that no man should be harassed twice over the same cause. So basically this maxim is to the effect that you should not punish a human being twice over the same thing. Okay, this would actually amount to double punishment, and it is unjust. It does not serve equity. It is unfair. And the law recognizes that the moment you sue someone and you get a judgment, it is unfair for you to still go on and sue the same party again. That's why the doctrine of res judicata has to come in to stop you, okay, from misusing the law, okay, and from harassing someone over and over again over a matter that has actually already been settled. Those are basically the two maxims on which the doctrine of Resjudicata, or also known as claim preclusion, is actually based. Finally, ladies and gentlemen, let's proceed to look at the factors that have to be met for a party to rely on the doctrine of res judicata. Okay, so number one is that the court trying the former suit must have been competent to try it. So, of course, this doctrine will apply where the court that actually had the previous suit was competent to try it. It had the jurisdiction, it had the powers, and so on. Secondly, the parties must have had litigation under the same title. This is very important, meaning that in the previous suit, if the suit was, let's say, Mutiaba Conrad versus Justin Naluoga, this second suit that is being brought, it must also be Mutiaba Conrad versus Justin Naluoga, meaning that these are the same parties. They are litigating under the same title, and therefore the doctrine of res judicata in such circumstances would apply. Then number three, the litigation must be between the same parties or representatives of those parties. So meaning that it could either be the same parties or their representatives. And then number four, the failure to agree on the merits of the case for lack of evidence shall not preclude the case from being res judicata. So here basically what we are meaning is that if in the previous case you lost the case because maybe you failed to bring enough evidence or to argue your case successfully, that does not in essence prevent the case from being res judicata. Okay, I encourage you to look at the case of Saleh versus Fouad. It's a case of 1960 East Africa, page 92, for purposes of that principle that I've just stated. Okay, basically that is it, ladies and gentlemen. Thank you very much for listening in. Again, before we end our class, I encourage students who require maybe some help or private tutoring, you need that extra polish, that extra touch by an expert, please feel free to reach out to us. These private engagements with the experts really work, and all students who have been on our program have been proven to always outperform their fellows who do not have any sort of mentorship. Our numbers are down in the description box. Please contact us and we'll be able to help you. Also ensure that you subscribe to our channel and also turn on your notification. Share this video with your colleagues so that they are also able to benefit. Thank you very much for listening. I'll see you in another class. Bye-bye.